and we're jumping into another in the Litigation Sucks series. Okay, so today's topic, litigation sucks. If you're in the construction industry, you need to have an arbitration clause in your contract. All right, first off, you most definitely have to have a contract, but that's a whole nother episode. So once you have the contract, one of the main things that you need in your contract is that disputes will be resolved through arbitration. Okay. So before we dive into that, I'm going to dive into three words that are sometimes used interchangeably, but are very different. So those are mediation, litigation, and arbitration. So first off, arbitration and litigation result in a final decision made by a judge or an arbitrator or a jury. Mediation is a voluntary process that you can agree to settle or not. So let's start with what mediation is. And usually, if your contract or if you're signing somebody else's contract that has an arbitration provision in it, it will require you to go to mediation before you move forward with arbitration. And mostly that's done through the American Arbitration Association or AAA. But what a mediation is that both sides come to the table, they present their side of the story to each other and to an independent neutral third party who's not going to make any decisions in the case, who's just going to listen. And then we go back and forth making offers to try to settle the case, right? Whether that's money, who's going to pay who, fixing things, whatever. We go back and forth. And through this process, you're always trying to leverage your position on both sides. So you really find out, even if you don't settle, you really find out all of everything that's in the other side's closet, like what they have, what they're going to try to use to prove their points in a litigation or an arbitration if you don't succeed at settling it at mediation, right? And so you go back and forth, and if you settle, that's great because then it's over, the dispute is done. And in my experience, any good mediation that settles, both sides leave pissed off. You're not going to get everything you want. Neither is the other side. But the good thing is that it's over. You don't have to move forward. You don't have to keep paying lawyers. You don't have to, get ready for trial, get ready for the next hearing. And you can do it while you're still in control of the case. Because one of the things is that when we don't settle the case, it's out of our control. We can do everything we can to get ready, but somebody else is going to make a final decision on your dispute, right? And that's kind of out of your control. So when you settle in mediation, it might be not exactly what you want, but it's still something that is very much in your control, and you know what's going to happen. As for with like moving, so the other options are litigation, and this is normally referred to. This is normally what you think of when you go to court. All right, so litigation is what I'm talking about. Courtroom litigation, where you file in your local county or your district court to get a dispute resolved, and that's mostly, if you don't settle on your own, how civil disputes are resolved by a judge or a jury in the public court system. And that is litigation, right? And so, you pay a filing fee, you file your case, you get the other side served, and you get forward with which if you don't settle sometime before trial, the final resolution in litigation is putting on a trial in front of a judge or a jury, who then issues a final decision, right? Okay. So that's who issues the decision in litigation in a normal courtroom litigation. Arbitration still comes to a final decision, but it's through a private company, the American Arbitration Association, that the parties agreed to go to. And usually it's in the contract that if you're a commercial subcontractor or commercial contractors, there's usually an arbitration provision in your contract that says if there's a dispute, you'll file with the American Arbitration Association. And so you're doing that instead of going to the public court system. And so what arbitration is the party agree in this agreement to resolve their dispute through this private process. And so an arbitrator is not a judge, right? Because they're not an elected official, but they act like a judge over your matter. And so usually what happens is they're an attorney that's familiar with the industry, or somebody who's got experience in the industry. And they don't always have to be attorneys either. It could be former judges, or somebody who's worked in the industry for a long time. So they don't necessarily have to be an attorney. So once you file an arbitration, you get to pick from a panel of usually like 12 or 13 they send you. And first you look for see if that there's any conflicts, and then you kind of rank them in the order that you would like. And so does the other side. And then you end up with an arbitrator that way. Most cases have one arbitrator. If it's a big enough case, you can have 3 arbitrators. But the thing is that they're familiar with the construction industry. They know how it works and how that is different than every other industry, right? And so why that is helpful to someone in the construction industry is because, generally speaking, judges and juries know nothing about construction, right? How you operate as an industry, how, in the commercial side, you work and then wait to get paid, how on the residential side, how things are not perfect towards the end, and you have a punch list and then you'll finish, right? So they have no idea how the industry works, and it really works against you going into a public court system like that, because first you have to, and most of the public court system, construction cases or mechanics lien cases are not what judges normally do. They do a lot of, a lot of collection cases, debt collections. They do a lot of personal injury cases, but construction is a minority, right? It's a small amount of what they do. And so they're really not familiar with the industry. And most judges I've talked to would rather deal with anything but a construction case, especially a mechanics lien case, because we get in the nitty gritty of what the law says, and it's not what they do on a normal basis. And so, and then juries are homeowners. They don't work in the construction industry. They don't understand how it operates. So, I had a client once that was wrongly terminated by a homeowner because he was getting close to finishing, but he wasn't all the way done, and he had missed things. He hadn't finished everything 100%. Like there was gaps between the stone and just things that would have been picked up in the punch process. But the owner got frustrated and didn't know about the punch process because my client didn't do a good job explaining that to him, that yes, there are these small issues, but at the end, we're going to clean it all up. This is normal, right? And so when he left the job, all these issues were still there. And so what the jury saw was these pictures of cracks between stones and, scrapes in the paint, which are all very much not big deals, punch list items. But to a juror who's very much a homeowner before they are a contractor, they're like, oh my God, I can't believe the contractor left this place like this. It's such a mess. It's going to take forever to fix. And so my client, obviously ended up losing, but it's not necessarily because he did anything wrong. It's just, number one, he didn't explain to his client what the punch out process was. And number two, you couldn't explain it to a jury either because they just don't relate to that, right? So when you're in front of a judge or a jury from the construction industry, they don't know how to relate, especially on the residential side. They're going to relate to a homeowner before they ever relate to a contractor, right? Because they're homeowners. If you're lucky, you might get maybe one person that's in the industry or know somebody in the industry, but it's just not beneficial. So like arbitration, you go in front of somebody who's industry specific, who knows what questions to ask, who knows what things to look for, who has been through construction projects or through construction litigation as an attorney for several years. So they know how the industry works, right? And they're familiar with the laws because that's what they do. So it's hugely helpful to have and it's less biased, right? Because we're all in the construction industry. We're not going to be biased by somebody who doesn't know what we're talking about because we're dealing with construction issues. Because we have an arbitrator who is founded in knowledge in the construction industry, which I know that's what you guys do every day, but it is not what most people do every day. So they don't know how it operates. They don't know how it works. So it's very important that we have, if we get the opportunity to have our disputes decided by somebody who's familiar with the industry, because it's a big part of getting a fair decision. The one thing about arbitration that is kind of a turnoff at first is that it does cost a lot more to file your claim in arbitration than it does in the public court system. Normally, the public court system to file a case is somewhere between $3,000 to $6,000, maybe $1,000 on the high end. And arbitration is based on the dollar amount that you're seeking, and usually is at least a couple grand, right, just to get it filed. And then you're going to have to pay the arbitrator to hear your case and to make decisions because he's an independent party. He's not paid like a judge is an elected official who is paid by the government, right? So our guys are private individuals who need to be paid. And so as part of agreeing to go to arbitration, you agree to pay their fee. So it does cost more upfront. And then you'll have to pay the arbitrator if he actually has to make your decision. But where you save money is that arbitration's got way less rules than the public court system. So part of what it gets so expensive in the public court system is the continual fights over the rules of evidence. What documents do you have to produce to me in the discovery process? Trying to set up depositions and all of this stuff. There's not all of those rules in arbitration. So it's like, if you have it, you need to turn it over. If you want to use it at arbitration, you need to turn it over, right? There's no real exclusions or things that come out. So like, everything's coming in. So if you wanted to win your case on a legal technicality about keeping evidence out, then the public court system would be your way, because there's books upon books of the rules of evidence in the public court system. There's not that way in arbitration. And the other thing too that makes arbitration more affordable is, in the long run, is the time it takes to get to an arbitrator if you don't settle at mediation, right? So the public court system is a year, maybe two, before you can actually get to trial in front of a judge or a jury. And that whole time you're going through discovery and you're spending money and you're doing all this. At arbitration, you can get to the, even a decent sized case to an arbitration hearing in 6 or 9 months, which means there will be a final decision issued, right, at the arbitration hearing. So it's might cost more upfront, but in the long run, it's going to save you in attorney's fees. It's going to save you in time, because it's just a smoother process. It's not as bogged down as the public court system. There's way more arbitrators, obviously, than there are judges, because they're not, elected officials. And from my experience, you get a fair decision, especially if you have two industry people going at it. This is normally in like the commercial world, a subcontractor and general contractor, or owner and a contractor. People who are both in the industry, having someone who specializes in the industry decide their dispute is hugely helpful. And especially in residential construction too, because homeowners don't know about construction and they can use that to their advantage in the public court system. But in arbitration, you really have the advantage because you speak the construction language, and so does the person deciding the case, and they know how things really work in the industry, and they don't have, sometimes homeowners can have unreasonable expectations, which is how we land in arbitration in the first place. So that they have more realistic expectations of what is good performance in the construction industry too. And so I say that too, in all situations, well, especially in the residential construction industry, if you want to avoid disputes, right, in the residential construction industry, the best thing you can do is have a well-written contract that explains what's going to happen, because a homeowner has an idea of what's going to happen on the construction project, but it's not really aligned with reality. And if we don't take the time to say, no, this is what it really looks like, then when it doesn't go with the way they think it should, that's when we end up in a courtroom, and that's when we end up in trouble. So with all that in mind, have a well-written contract. If you don't have one, give me a call. I do them in all 50 states, state-specific, for a flat fee with a 5-business-day turnaround. Very affordable, something you absolutely need to protect yourself. I don't care if you're a handyman or if you're building new houses, you absolutely need to have some kind of contract that's more than just a scope of work. The scope of work is important, but there are other important things too, that if we have in there, when we clearly describe what's happening, you're a lot less likely to end up in litigation, just because, trust me, litigation sucks. And why does it suck? It's expensive. It's time consuming, right? And here's the thing, you think I'm going to go to court, I'm right, I'm going to get justice. That's not how it works. At least not in the civil court system, is that there's so many shades of gray and so many issues in 2 years to get there. And it never turns out. The best you can hope for is to break even. And I've never seen a case even do that. Because it doesn't pay for your time, the time you have to spend for going depositions and all that. You might get your attorney's fee back. You might get interest on that. You may get the amount that you're actually claiming. But again, if we're leaving the outcome of our case to somebody else, we're going to do the best we can to present the case. But at the end of the day, we have no control over what the decision is. So, litigation has to happen sometimes. I think for people in the construction industry, probably the best way to go is arbitration, because it's faster, more efficient, and decided by somebody who's got experience in the industry. If you need ideas on language to put in your contract, feel free to reach out to me, send me an email. We can talk about what that looks like. I probably have some free language at subcontractorinstitute.com, which is my free educational resource if you're looking for language that you need to add to your existing contract. But if you don't have a contract at all, we need to fix that too. So give me a call. We have a great contract division in my law firm that does 5 business day turnarounds, and it's a custom contract for your business, whether that's the pond business, a pool business, remodeler, a home builder. It's very specific, and we've had experience with all those different types of builders and people in the construction industry. So we kind of have an idea of what's important to you. So, all right, guys. Well, if there's any other topics you want me to discuss, you may be interested in, feel free to email me. Put it we'll put all our contact information in the show note. Reach out on social media. I'll always be around. All right, guys. I hope you have a great day. Thanks.